Also, thanks for the invitation. Glad to be a participant in this seminar. What this next half an hour is about is on the value of the integrity of online news archives in relation to what is called the right to be forgotten. And we look at that from the perspective of Article 10 of the European Convention. I sometimes call it Europe's First Amendment, in the article which protects our freedom of expression and the right to information. And we will highlight a case of last year in which the Grand Chamber of the European Court put forward the principles. The structure of the presentation is we take a little step backwards to understand the context. Where is this right to be forgotten coming from? How has it been developed in several stages? We look at the data protection law in the EU with the famous Google case on delisting, and then the General Data Protection Regulation of 2016, which introduced a right to be forgotten. We look at the earlier case law of the European Court of Human Rights, in which the value and integrity of online media archives was firmly emphasized. And then we come to more recent cases, the case of Biancardi versus Italy in 21, where it's not about delisting on the level of the platforms of the search engine, but the de-indexing at the level of the original online media article. And then we end up with the most, how would I say, the most influential judgment by the European Court for the future, the Grand Chamber judgment of last year in a case of Hurbain versus Belgium, Hurbain being the editor of a big journal in Belgium, Le Soir. And we end up with some reflections and Q&A, as you just did in the session with Nathalie. I'm sure that all of you are familiar in some way with the Google Spain case, where the Court of Justice of the EU opened the box of Pandora, you could say, with regard to the notion of the right to be forgotten. Although you will not find these words in the judgment of 2014 and the Google case, it was about the right to remove the links to a person in the search results about that person. And the European Court recognized that data subjects, on the basis of the directive at that time, could have a claim under some conditions to have these links to their search results and name removed, even if the reference to the pages that pop up is lawful, but just the data protection is enough. Also, somewhere in the considerations of the judgment by the Court of Justice, it was referred to that there is a right to erase these search results when personal data are inadequate, irrelevant, or excessive, or are no longer necessary unless there are some other important purposes like historical, statistical, or scientific. So this was a recognition of data subjects' rights to have, at the level of search engines, the delisting of the links. It was also important that the Court of Justice underlined that such a right existed for a data subject without needing to give any evidence of harm. It was just the processing of the data itself, which were no longer necessary, which gives the right to erasure. So that is an important element. It also added, it continued to give it a very important status, this right to erasure, that it said that such a right of the data subject took priority over the interest of the general public in having access to that information upon a search relating to the data subject's name. So the right of erasure became more important than the right of the public to be informed about that person. But then at the end, there was a kind of a disclaimer. However, the Court of Justice added that such a right would not exist if there were very particular reasons that the data subject played or had played a role in public life, that the interference with the rights of the data subject could be justified by a preponderant interest of the general public to have access to that information, but only in very particular cases, preponderant public life. So that became the exception. And the right to erasure became a very strong principle. Further development of these guidelines can be found in the Data Protection Working Party document of 2014, where they tried to give some more guidance how to apply this delisting principles which have been established by the very controversial judgment by the Court of Justice of the EU, but of course it was a very important judgment with an important impact in Europe and outside Europe. Then came the General Data Protection Regulation of 2016, in which explicitly a right to erasure and for the first time the right to be forgotten, but between brackets it was not completely a right that the GDPR wanted to install, but it was referred to as the right to be forgotten. What is important here, it's not only about delisting, it's about every processing of personal data where there is a right to obtain the erasure of these personal data when they are no longer necessary, for instance, or under certain conditions where the data subject objects and there are no overriding grounds to keep that information about that person. What is important here is, although that Article 17, which introduces that principle, also contains a disclaimer and a bit stronger than in the judgment of the Court of Justice. It said that this right of erasure shall not apply to the extent that the processing is necessary for exercising the right of freedom of expression and information. And for those who didn't understand already this very important exception, there's also Article 85, in which the GDPR very strongly emphasizes the need to balance equal rights of data subject and the equal rights of access to information and freedom of expression for those who want to refer to persons' names. So the member states have to reconcile in their legislation and in their jurisprudence the balancing between the two. So there's not that much a priority anymore. They need to be in balance with each other. And Article 85 specifically refers to journalistic purposes and who can justify the use of names and the continuous use of names in their reporting. That was the development 2014, 2016 at the level of the EU. In the meantime, the Strasbourg Court had already been confronted, had been requested to deal with issues on what we could call the right to be forgotten, or at least also about the issue of online media archives, where persons ask that something would be removed, would be altered, would be delisted. There were a few cases. The first one was already in 2009, before the Google Spain case, where the European Court had to deal whether in the United Kingdom an order to publish an online notification on an online media article was whether or not in breach with Article 10. And what is very important here is that the European Court put forward some standard principles that we need to be that need to be considered, that we need to be aware of when we start interfering with the archives, online archives, and specifically archives of media, of newspapers, of radio and television, of websites. As you can see, the European Court recognized the substantial contribution made by these archives. They are an important source for education and historical research. There's the accessibility and capacity to store and communicate amounts of information, and there is the public's right of access to news, which is facilitated also by this archives. In this case, the European Court found that Times newspaper was not ordered to remove any content or to alter any content or to delist or to de-index any content with regard to potentially defamatory articles where a case was running about. The court underlined that Times newspaper was requested to publish an appropriate qualification to an online article, that a libel action had been taken against that article. So it was added information for the public that the case was running with regard to that article. And therefore, the European Court found that the order to publish this online qualification was no violation of Article 10. It didn't damage, it didn't ruin the integrity of the archive. It was an additional notification to the readers that they knew some more context about it. And a bit in the same line with some same considerations, in the case of two lawyers against Poland, and I don't try to pronounce the name of these two lawyers, who had won a defamation case against a newspaper at a certain moment, and they wanted that also the online version of that newspaper article would be removed from the archives of the newspaper. They brought a case in Poland to have this removed, but the Polish courts rejected this request, and that's why these two lawyers went to Strasbourg, because they said it's an Article 8 case, that their right to privacy and reputation was not sufficiently protected in Poland because of the non-removal, because of the refusal to order an order to remove the text. The European Court, in a very important consideration, I think, said that it is not the role of the judicial authorities to engage in rewriting history by ordering the removal from the public domain of all traces of publications which have in the past been found, even by final judicial decisions, to amount to unjustified attacks on individual reputations. And you can see here a very strong reluctance by the European Court to interfere with the integrity of the news archive, and not the role of the judiciary to rewrite history. The court also took into consideration an interesting and an important aspect of the case in Poland, that the courts had suggested in Poland, instead of removing the defamatory content from the internet, it would be desirable to add a comment to the article of the website informing the public about the outcome of the civil proceedings in the defamation case. So no removal, no alteration, like in the Times newspaper case, eventually an online qualification, additional content, but very strong position by the European Court. We don't touch on the integrity of online media. Archives, and Article 8, the right of privacy and reputation, cannot be so strong that we start interfering in this very important value of integrity. And this was also approved and confirmed, condoned in a case against Germany, in which the European Court dismissed again an Article 8, right to be forgotten, application in respect of some online information on 3 German media portals, of which Der Spiegel was certainly the most important. And the European Court confirmed that the media have the task to participate in the creation of democratic opinion by making also old news items available through their online news archives. A very important principle of the task even of the media to keep this historical history, this historical memory intact. The European Court observed that in this case, the applicants only asked for the anonymization. They didn't ask for the removal of the articles, but they wanted their names removed. So this was only a minimal interference. And it was also asked in the period that the two guys who had been in jail for murder for some time, they were released on probation. So it was important to give them a possibility of resocialization in the community. But the European Court said, yes, these are important principles, but also archives constitute an important source for education and historical research, particularly as they are readily accessible to public and general free. What the court did in this case, it was the classical balancing test, as we know it since 2012 in the Axel Springer case, where the court has said Article 8, Article 10, they have the same value in the convention. We need to balance them, and the court has developed criteria how the member states, how the judicial authorities in the member state should balance this right according to 5 or 6 different criteria. And here, especially 4 were strongly focused on. And European Court emphasized also the importance for the press to be able to refer to the names of persons who have been involved in court cases of considerable public interest. And that right was very strongly emphasized. The articles were true, they were lawful, and the two applicants also didn't apply for any delisting at the search engine. They went directly to the original archives to have their name removed. And refusal by the German courts to order the anonymization did not violate Article 10. And so again, a very strong judgment in the direction of keeping the integrity, even if it was only anonymization, even if it was very relevant for these persons, for their social rehabilitation, still other important principles that you just heard at the side of Article 10 were preponderant to agree and to justify with the application, with the approach by the German courts. And then we see some shift over the years. Then came the case of Biancardi, which was not about anonymization, was not about delisting, was about de-indexing at the level of the platform, of the media itself, to disconnect the media archives to the search results by search engines. That was the request, and that was awarded in Italy. The editor of an online newspaper was held liable in Italy under civil law for not de-indexing an article at the level of a media platform on request of a private individual. And the European Court found that the editor was liable for not de-indexing the article. The court, European Court in Strasbourg, referred to an obligation to de-index material, that such an obligation can be imposed not only on internet search engine providers, but also to the administrators of newspapers, of journalistic archives. And this was an important shift with regard, for instance, to the Google Spain case, where it's about delisting. And now it is also brought on the level. The obligation is also applicable for administrators of newspaper or journalistic archives. The European Court emphasized that there had not been an order to remove the article, to alter the article. There was no anonymization. It was only de-indexing of the article at issue. The article could stay there in the archive, but it could not be found anymore through the Google and other big search engines when you used the name of the person which had requested for the removal, or better, for the indexing of the article. And therefore the court found that the liability imposed on the editor for not de-indexing the article was not a violation of Article 10. It was a controversial judgment. Many argued that from now on, access to news archives were in danger because you access these news archives through the search engines. It's an extension of the right to be forgotten from delisting to de-indexing. And this duty, not only for search engines, but also for online media archives, would put an enormous pressure on online media archives when they are requested to de-index some of their articles. And then came the case against Belgium, Hurbain versus Belgium. The case here is also the online media archive of the biggest French-speaking newspaper in Belgium, published in Brussels, Le Soir, where there was an order of anonymization on the basis of the right to be forgotten, in which the court balanced Article 8 and Article 10, like it did in the German case, as we just saw. And the European Court Chamber section found that an order by the Belgian courts to anonymize the name of a driver, Mr. G, who had caused a fatal accident more than 20 years ago, and which was reported in the printed version of Le Soir, that this online article should have been anonymized, and this was not a violation of Article 10, because here it was the publisher who complained about the interference by the Belgian courts, but the European Court said, the Chamber, this is no problem. There are sufficient reasons that the right of privacy, of data protection here for this old facts of a non-public person should prevail, Article 8 over Article 10. And that caused an enormous discussion about the integrity of news archives, because here it's not about de-indexing, it's really alteration of the content by removing the name of the essential actor in a news article. There was a strong dissenting opinion in this chamber judgment by the Albanian judge Pavli, who warned that with this judgment, the European Court went into a very dangerous direction, and that the digital press archives would become less accurate, less complete, and that there would be better measures to take than to interfere with the content, even if it is only anonymization. As I said, the case produced quite some controversy, and there was a request by the publisher in Belgium and lawyers supported by a very strong coalition who introduced the third-party intervention in order to support the request by Le Soir, let's say, Mr. Hurbain, to reconsider the case at the level of the Grand Chamber. And as you know, it's very difficult to pass the filter of the panel, but when the panel finds that a case really needs to be, needs a more closer look to keep the consistency of the case law of the court, or because it's a very important issue which is new before the court, then there could be a reason to refer the case to the Grand Chamber, which effectively happened in this case. And the Belgian jurisprudence would be looked at again at the level of the Strasbourg court. And the court indeed emphasized that it was a very new issue that it had to deal with. It had not been dealt until then by removing or altering information which was published completely lawfully with regard to the archives of a website of a news outlet. And again, the court said we will look at this case to be consistent with our case law in the balancing exercise of Article 8 and 10. And I can already say it found no violation, so it confirmed, but with a better argumentation, I would say, the chamber judgment of 2 years before. The court very strongly emphasized, again, the value and the integrity of digital press archives, like it did in earlier case law. So it was not inconsistent with that case law. It very strongly emphasizes this principle. And it also said that the integrity of digital press archives should be the leading principle. So that is absolutely very important. We need to preserve memory, and that is the way how we do it, by keeping the integrity of news archives. On the other hand, the court recognized that an individual can have a legitimate interest in obtaining the erasure of some information, the limitation of access, or eventually the anonymization. And when the damage is sufficiently serious, and that's also a difference with the Court of Justice here, when there is sufficient harm, potential harm to the data subject, there can be a legitimate reason to do something in order to protect the right of privacy. The court also explained the difference between delisting and de-indexing at the level of the original platform. There are two different forms of processing, but both can lead to action that is to be taken in order to preserve the right of privacy. The right to be forgotten is not a right as such recognized by the Convention and by the European Court. It is part under Article 8 of the right to privacy and reputation. And as you can see, the court has developed a set of 7 criteria which can be very helpful also for the national courts in order to balance these rights in the context of the anonymization request at the level of the platform. The most relevant arguments that the court took into consideration is that the article had no topical, historical, or scientific interest. G was not a well-known person, just a local doctor. The serious harm suffered by G as a result of the continued online availability of the unrestricted access to the article of 20 years ago created some kind of a virtual criminal record which kept on being there online. It was 20 years ago. The anonymization was not very excessive and difficult to do, and the interference was limited to what was strictly necessary according to the court, and therefore it saw no reasons to substitute its own approach instead of the one which has been followed and the reasoning of the Belgian courts, no violation of Article 10. Again, a controversial judgment, a 12-5 majority, 5 strong dissenting opinions, very elaborated in the annex of the judgment. I try to summarize. Most important argument by the 5 dissenting judges is that the harm invoked by the person named Mr. G in the litigious lawful article was not serious enough in order to justify the alteration of the online version of the newspaper article, because Article 8 is only applicable when there is serious harm, sufficient serious harm. This was not the case. And then they also said such an alteration, be it an anonymization, is disproportionate because this is so much interfering with the integrity of news archives that it becomes disproportionate. So to end this overview, the question is, what is most detriment? What is the best way to try to reconcile the right of the data subject and the right to freedom of expression and information? How to bring this in the right balance? What is the best way? Only delisting, or also de-indexing? Or is anonymization the least interference what can happen? Can one ever accept alteration? When one accepts removing names, why would one be able to have also other content removed, or eventually the complete removal from the original media platform archive? What is so problematic about anonymization is the question here also, and it really helps to secure the reputation and privacy of a person about something which happened so long time ago and has no public interest. What would be a less interference to meet the needs of the data subject? And then here, the balancing of Article 8. Shouldn't the court do a more strict scrutiny instead of leaving a quite broad approach to the member states? Was there a serious harm for the person who invoked his right to be forgotten? And what about the future? Will also legal persons be able to do that, or will it only be individual physical persons? Was the balancing okay by the European Court? Does it not have a chilling effect, this kind of judgments by the Grand Chamber? And I hear and I see reports in different countries by media that now they get more and more requests to remove names at the level of their media archives due to the Hurbain versus Belgium judgment. And there is an attempt, or there is an approach maybe to remove the names of persons in order to avoid court cases at the level. So there's a risk of overbroad anonymization, removal in case of request based on the right to be forgotten, which of course has a negative impact on the integrity of our collective memory held by the online archives. For those who want to follow this case law, this interesting case law, fascinating case law with some bit a long and winding road sometimes, can of course follow free online the Iris newsletter, reports monthly with a prominent place to the case law of the European Court, especially with regard to internet and journalists. And I can also, of course, it's a bit product placement, the fresh published 9th new edition of the overview of case law of the European Court on issues of freedom of expression, internet, media, and journalists, which is also free online, available, published by the European Audiovisual Observatory in Strasbourg, and which is a synergy between the EU and the Council of Europe. Thank you for your attention, and of course I'm available for questions